Well, good afternoon, everyone. My name is Anthony Damsis, and it's a real privilege and a personal honor for me as chair of the Canada branch of the Chartered Institute of Arbitrators to present this year's award for distinguished service in Canadian arbitration to someone who needs no introduction, Mr. Bill Horton. This award is reserved for those who have not only excelled in their own practice, but who have also contributed meaningfully to the growth and integrity of arbitration in Canada. Bill has done both of this, consistently, generously, and with a spirit of service that makes this recognition particularly fitting. For many of us, Bill has long been the go-to person in arbitration. His work is respected, his views are sought after, and his guidance, whether given in writing, in practice, or in the classroom, has helped shape the direction of arbitration in this country. He's a genuine thought leader, clear, principled, and always ahead of the curve. But what makes this award so well-deserved is not just Bill's expertise and experience, though it is considerable. It's how willing he's always been to share that expertise. Time and again, Bill has stepped forward to support the arbitration community in both ways that are large and small. Personally, I've had the pleasure of calling on him many times over the years, sometimes for a session in a course I teach, other times for our accelerated route to fellowship program, which we just finished this weekend, and every single time, Bill has said yes. Not only does he say yes, he shows up prepared, insightful, and committed to making the experience better for everyone in the room. And of course, he is the architect of the Toronto Commercial Arbitration Society's Gold Standard course, a program that many of us regard as exactly what its name suggests, the benchmark of arbitration training in Canada. That course has helped educate and inspire an entire generation of arbitrators, many of whom are in this room today, and it continues to be a model of what thoughtful, well-structured training should look like. But even these formal contributions only tell part of the story. Bill has also given his time, energy, and insight to shaping the very foundations of arbitration practice in Canada. He was instrumental in the recent overhaul of the ADRIC arbitration rules, working with colleagues across the country to modernize and improve rules that we all rely on. That kind of work often goes unnoticed, done behind the scenes, without fanfare, but it's the kind of work that makes a real and lasting difference. And through it all, Bill has never sought the spotlight. He's content to mentor, to support, to write, to speak, all with the aim of making arbitration in Canada stronger, fairer, and more effective. He's chaired tribunals, advised on complex commercial and investor state matters, written extensively, and taught with generosity. But he has also made space for others, especially younger practitioners, and helped foster the kind of arbitration community we all want to be a part of, one that values quality, fairness, and integrity. It's often said that true leadership isn't about being the loudest voice in the room, but about helping others find theirs. Bill has done that time and again. This award is Ciarb Canada's way of saying what so many of us already feel. Thank you, Bill, for your wisdom, your generosity, and your enduring commitment to this field. You've set an example that many of us aspire to follow, and you've left an imprint on arbitration in this country that is impossible to overstate. And this evening, we're doubly fortunate because after we present Bill with the award, Bill will deliver a keynote address on the topic that could not be more timely and important: legal culture and commercial arbitration in Canada. I know I speak for many when I say we're all looking forward to hearing his reflections and insights. So, with deep appreciation and admiration, it's my pleasure to present the award for distinguished service in Canadian arbitration to Bill Horton. Congratulations, Bill. It's richly deserved. And we give you the floor.
Thank you so much, Anthony. It sounds pretty good when you put it that way. Barely recognize myself in the comments. The reason I always say yes is usually because I don't really have anything better to do. But anyway, I'll take the way you have put it. This is actually a great honor, all kidding aside. The Chartered Institute of Arbitrators has been very instrumental for me in my career. I actually got the fellowship designation in 1997 based on a course I did in 1996, and I can tell you with all honesty, at that time I had no arbitration practice whatsoever. And very little, if any, experience doing arbitrations even as counsel. So the standards were a lot lower in those days. But the kind of the fun thing about it is I took the course with two other friends of mine. We were all attending the IBA conference in Berlin at the time, and this course is the arbitration, the accelerated routes to fellowship course, I don't think it was called that then, was offered in the margins of that conference. And we just decided, what the heck, the three of us will take it. Well, the other two were Peter Rees and Michael Lee in London. And certainly they made good use of the fellowship designation. And I feel it's inspired me as well. It was about 10 years later, almost exactly 10 years later, that I left Blake's and a career as a commercial litigator to pursue a career as a full-time arbitrator. So it really was the beginning of my journey. For many people, it's closer to the end of the journey. But it's played a tremendous role, and then subsequently, most of my contact with the Chartered Institute has been teaching the accelerated route to fellowship course. So it's kind of been a circle that way. Anyway, it is really a great honor to be recognized and also to be in the company of the prior recipients, of course, many of whom are in the room. I don't want to mention any names, I'll probably forget and leave somebody out, and I don't want to do that. So I was, along with the award, I got the opportunity to say anything I wanted to say, which is probably, for those of you who know me, more valuable than the award on any given occasion. And you have to put up with what I have to say for a little while. I advertised, the topic I chose based on what I really wanted to just say at this moment in time was legal culture and commercial arbitration in Canada. The in Canada needs a little bit of explanation because all it really means that I'm not talking about arbitration that takes place anywhere else. As far as the in Canada part of it is concerned, I'm really only talking about Ontario. That's for a couple of reasons, one of which it's kind of a dangerous time for people in Ontario to be making comments about other provinces, so I stay away from that. But if the shoe fits, wear it, or if something's applicable, by all means, feel free to take advantage of it or to disagree with it. And the other reason is that what has prompted this is this Civil Rules Review Committee that we've just had, it's ongoing in Ontario, where there's been a kind of a project to review the civil justice rules, and that has given rise to a lot of thoughts in my mind, not just about civil justice, and which many of us have participated in for a big part of our career, but also how that relates to what we're trying to do in commercial arbitration, and also to some degree the fact that many of the cultural aspects of litigation that are evident in the civil justice system are sometimes also holding us back in commercial arbitration. And I think we've sort of seen that through our discussion today, where very often we have these wonderful expedited approaches, and then the anecdotes are, yeah, but counsel are pushing back, or it doesn't quite work out that way in practice, and I think that's often the reason. So not very long ago, I was reading the Court of Appeal daily feed, and there was a case that caught my attention, and it was a case about brokerage rights relating to a billboard, electronic billboards. Okay, it's a pretty big billboard on the Gardiner Expressway going into Toronto. What caught my attention about this case was that it had been going for 10 years. 9 years to trial, 1 year to the appeal. Apparently, so the trial judge awarded $1 million worth of damages, something like $2 million for prejudgment interest based on the contract rate. It was, if you dug into the record a bit, you'd see that each party had spent well over $1 million. So, 10 years to decide on rights to put ads on a billboard and twice the costs of the actual damages. Not really a good result. So I took a copy of this case, I actually posted a summary of it on LinkedIn and sent the link to the two co-chairs of the Civil Justice Review Committee and said, yeah, here's something. Well, of course, it was Coles to Newcastle because they knew about the case, and they, like we've got so many other cases like this in the province. That's really what the problem is here. So I didn't need to have worried about them not knowing about it. When their report came out, they cited, they really didn't pull any punches. They cited a Globe and Mail article that described the civil justice system in Ontario as arcane, expensive, and plagued with delay, in short, in crisis. They went on to add their own assessment. The crisis has only deepened since then and may now fairly be described as existential. Existential. Absent impactful reforms, our civil justice system risks becoming irrelevant. So, of course, they reference the famous quote, Justice Karakatsanis in Herniak and Malden, which called for a culture shift in order to create an environment promoting timely and affordable access to the civil justice system, and that's the project in which they were engaged. The context of the Herniak and Malden case was a motion for summary judgment, and the basic concept was, flowing from that decision, let's accept less process, we don't have to have perfect justice, and summary judgment is a way to do this. So the focus was kind of on summary judgment as the solution. The Herniak decision had come out in 2014. In 2015, there was an article published in the Advocates Quarterly, and the authors had reviewed over 400 cases across Canada that had referenced Herniak and found that there was a 10% increase in the granting of summary judgments. And their conclusion was, so the case is having a very positive effect. So, well, that was easy, except that, of course, it wasn't, because the summary judgment was not the solution. Focus on summary judgment was not the solution. And the second report of the Civil Justice Review Committee tells us why. Going to trial is so expensive that many litigants will take a chance of succeeding in a summary judgment motion even where it's not actually available. The resultant setting aside of summary judgments, which, by the way, the whole process can take 1 or 2 years, occasions huge and wasted costs because for the parties and for the cost for the parties in the public system. So you might say the fire door was not designed to handle the number of occupants trying to leave the courthouse. That would be one way to look at it. Not the solution. Summary judgment, only the most recent of many different solutions pursued over the years in Ontario to The introduction of discovery was actually one of those ideas way back when, not only to prevent ambush at trial, but also hopefully when the parties know enough about each other's case, they'll settle and they won't bother the courts for a trial. But there's lots of other things that have come along the way, lots of other ideas, especially endorsed writ procedures, application procedures, rules to control motion practice, introducing the concept of proportionality, compelling mediation, limiting discovery that we originally introduced in order to make the system more efficient, expanding summary judgment, and lots of other tinkering with the rules. None of these efforts have produced the objective which Chief Justice Wagner has articulated as good justice for everyone and not perfect justice for a lucky few. So in my view, the Herniak decision was important, inspirational, and timely in a moment in Canadian jurisprudence. And frankly, although I've been an arbitration practitioner for now almost, say, 15 years since I got rid of my last counsel case, I still deeply feel that we need a functioning civil justice system. So where do we look? Where do we look for the solution? And I think that one of the things we have to sort of accept is that we need a deeper criticism. We need to actually look at some of our cherished values, which are good values, they're important values, but perhaps they're being misapplied. And some of that misapplication not only flows to the court system and primarily flows to the court system, but is also some of what we are having to deal with in commercial arbitration in order to have commercial arbitration fulfill its value proposition of being more efficient than going to the courts. In the Teal-Cedar case in the Supreme Court of Canada, Chief Justice McLaughlin observed that the overarching goals of commercial arbitration are efficiency and finality. From my perspective, the reason she had to say that in an arbitration case was because those goals are not necessarily fully embraced by members of the arbitration community, and they need to be reminded of that from time to time. And efficiency and finality are not just desirable goals in arbitration, they really should be goals in all forms of dispute resolution. We very glibly say justice delayed is justice denied, but the full truth of the saying has never really been internalized by the litigation bar, the arbitration bar, and I will be so bold as to say even by the courts themselves. For example, there is a rule, I think it's Rule 26 in the Rules of Civil Procedure, that define prejudice as something that can't be compensated by an adjournment or by an award of costs. So if you have a concept of prejudice that says it's something that can't be compensated by delay or a cost award, you're going to get proceedings that are too long and cost too much. It's not rocket science that you need to alter that attitude. You have to understand that delay results in costs, and especially if the delay results in proceedings being started and stopped and started and stopped with completely unnecessary costs being incurred when they restart. So delay breeds costs. Delay and costs are inherently prejudicial, should be viewed as inherently prejudicial, unless there's some good reason to avoid them. I'm suggesting there should almost be a reverse onus, and certainly in commercial arbitration, we should be operating on that basis. I want to say something about that. I mean, first of all, I'm not actually criticizing individual lawyers. I want to be clear about that, because if you're in a system that is inefficient, you can't take a minimalist response to a maximalist opponent, or you will lose the case and you will lose your client. So systemic reform at a kind of cultural level is what's needed. You can't do it at the level of the individual lawyer. And the other point that I would make when we're looking at things like the Civil Rules Review Committee or the revision of the ADRIC rules or any other rules is that the more rules, the more lawyering. Okay, and unless you reduce the lawyering, you cannot create more efficiency. Rules have to be written and looked at from the point of view that they are going to be used strategically, that they're going to be used, abused, and misused. And so therefore, you have to draft the rules with that possibility in mind. One very good example of this is, let's say you have expedited proceedings, rules for expedited proceedings. Expedited proceedings are a wonderful idea. But if you then say, well, they're only going to be available when there's a certain threshold is met, or for certain types of cases, or put any kinds of qualifications on when these expedited proceedings, you're going to get disputes about whether or not the expedited proceeding is actually available. And you're now going to have all kinds of, so think about that, and think about drafting rules in a way that either, first of all, minimizes the number of rules that are necessary, and that precludes the possibility of disputes about the rules. And if you take that approach, then the answer is that other situations that are not contemplated or defined by the rules have to be dealt with through some kind of discretion. And now we're talking about case management, essentially being necessary in order to address these sorts of issues. I just want to, because I definitely do not want to take you over time, I want to just briefly talk about three principles or values within our court system that I think need to be applied very judiciously, if I may. Maybe that's not the right word in this context, that need to be applied very carefully and need to be scrutinized. So, and I want these are values that everyone would agree are important to the system. Take the rule of law. In his decision in the Uber case, which I think most of you are familiar with, Justice Brown spoke of the rule of law as requiring access to an independent judiciary that can vindicate legal rights. While he acknowledged that the rule of law does not require access to a court of law in all circumstances, he held that where a clause expressly provides for arbitration while simultaneously having the effect of precluding it, the considerations which promote respect for arbitration dissolve. I agree with those comments wholeheartedly. But what of a court system that has the same preclusive effect in terms of access to justice for the vast majority of its users? If anything, the problem of preclusion in the court system is much worse, where parties may only realize the hopelessness of the legal process after having spent considerable time and money. As I said in a paper on evidence-first arbitration I wrote about 8 years ago, if the objective of the rules of civil procedure was to prevent cases from being decided by a judge applying the law to the facts, they would succeed in that objective over 95% of the time. So it is important, and as commercial arbitrators, we're called upon to provide some kind of an answer to that. And I think I'll just leave it at that for that topic. Another sacred cow, the adversarial process. Well, of course, we can all agree the adversarial process is essential to effective representation in any adjudicative process in a free country. Before an audience such as this, I don't need to go into why that is so, but I doubt that anybody would suggest or argue that the adversarial process itself improves efficiency or finality. There may be cases, and there often are, where both sides want to have an expedited process, and they instruct their lawyers accordingly. And where that's pursued, the damping down of the adversarial process is going to be involved in that somehow. In other cases, which are really the majority, most counsel are habituated to the adversarial model and lack the disposition or the expertise to pursue a cooperative approach in either the court or the arbitration context. So again, we come back to some kind of case management or supervision being necessary to deal with this otherwise very important value that we hold dear. In the absence of case management, a dispute resolution process becomes like a hockey game where there are no referees on the ice and all penalties are just decided by video replay. So, you know, it'd be a long game if it were that way, and this is what is causing a lot of the delay, I think, in the courts. The second report of the Civil Rules Review Committee rejected case management in the courts as achievable. In the sense of case management from beginning to end, as we have in commercial arbitration. And I think that's realistic. And I don't think, and by the way, the report doesn't put that down to a lack of government funding. Of course, everybody wants more government money, but it's simply not viable for 6,000 cases or so that are filed every year to have enough judges to manage all those cases from beginning to end. And that's the reason they put forward for rejecting it. Well, in commercial arbitration, we do have the opportunity to provide case management if we take advantage of it and if we understand that the purpose of the case management is to control the adversarial process. Counsel don't like it. They don't want to have their adversarial approach interfered with. But in many instances, that's exactly where we as commercial arbitrators have to step in. And I'll just, then my final value that I wanted to briefly talk about was due process. So due process is central to any dispute resolution system that operates within the rule of law, getting proper notice of claims and defenses and the issues that they raise, the right to be heard, an opportunity to present one's case, and so on, all very important. But the value of due process, the value of all of these elements are lost if they do not work together to produce timely and cost-effective justice. Efficiency and finality, and certainly in business disputes, and if we're thinking about our business clients and how they conduct their businesses, efficiency and finality is not a nice to have. In business disputes, it should be seen as mission critical. In arbitration, we've had lots of debates, including, you know, some that we've touched on today, about how much due process is too much. We have to understand that it is not an absolute value if we're going to deliver value to the users of commercial arbitration. And we have to understand that it is a culturally based choice as to how far we go. So for example, in international arbitration, there has been a huge debate about due process paranoia, how much due process is too much, how much independent power should the tribunal have, not just to control the proceedings, but also to actually direct the evidentiary inquiry that needs to take place to provide the evidence. And international arbitration is an amalgam of the civil system and the common law system. You have to say most of the efficiency comes from the civil law system. Most of the due process, what gives rise to due process paranoia, comes from the common law system. And there has been within the international arbitration community an attempt to arbitrage these cultural values. And the IBA rules on the taking of evidence represent one of the consensus points and the one that's most commonly used. Interestingly enough, the Civil Justice Review Committee is proposing a new approach to litigation, which will adopt something like the IBA rules of evidence, will adopt something like the evidence first arbitration that we've been using to make arbitration more efficient. But the fact of the matter is there are still arbitrations that are being conducted explicitly under the rules of civil procedure. I have one with counsel right now. We are in discussions, but the fact of the matter is that's what they've agreed to. It's very difficult to move off of that. And also, as we've discussed today, very difficult for counsel to move off some basic ideas about what minimum due process requires. And by the way, I'll say, as I said to someone at lunch today, when I started out being an arbitrator, I found it almost impossible to believe that there could be a fair process without examinations for discovery. I was as much in the thrall of the litigation culture and the court culture as anybody else. And it took a lot of time before I could see and develop some specific ideas for myself and with others that would show that in the vast majority of cases it really doesn't add anything. So I'll just conclude my remarks by saying, on the one hand, I think we all should be supportive of these efforts to change the rules of civil procedure. There's a huge challenge in that because these rules apply to so many different kinds of cases. As one of the chairs of that project said to me, you know, we're talking about 400 different types of cases in hundreds of different locations with different local cultures and so on. So it's really tough. We provide services in a very limited group of cases, but within that group of cases, we have the opportunity to recognize and address and ameliorate the effects of some of these core values. We really need to take advantage of it in order to deliver value to users of the commercial arbitration system. So thank you very much for letting me sound off on all of that.